Diddy says that he has proof that the government is spying on him. Diddy's lawyers just filed a motion to the judge asking for an evidentiary hearing, saying that the investigator that raided his jail cell and took pictures of the notes that were in it were actually spying on him. And they're responding to the declarations that were submitted by the government detailing exactly what happened when they raided Diddy's jail cell. Diddy is claiming the declarations show that ever since the government first tried to use Diddy's privileged notes to continue his detention, it has presented a materially false narrative about how it got access to these sensitive, privileged materials containing his defense strategy and his communications with his attorneys. Diddy is claiming that the declarations revealed that the Southern District of New York supervisors directed the BOP to search Diddy's unit because of its investigation and prosecution. They demonstrate that the government has consistently monitored Diddy's legal calls. In other words, they confirm what Diddy has been arguing all along, that the search was conducted based upon pretext, not for any legitimate reason, and that investigators won surveillance before and during the search violated Diddy's constitutional rights and invaded the attorney-client privilege. And I am preying on the fact that this information is not correct and this does not get Diddy a mistrial. The declarations expose that after the sweep began, it was unclear whether Diddy's unit would be searched at all. Moreover, the search of that unit was carried out specifically at the direction of the Southern District of New York supervisors, including the supervisor for this case, because of their interest in obtaining evidence against Diddy. Second, the declarations show that Investigator 1 became an agent of the prosecution team and worked to advance its case. He searched Diddy's bunk for evidence, not contraband. It is clear his purpose was to gather evidence for the prosecution, not police and any potential threats to the MDC security. Indeed, it is notable that even though he has been surveilling Diddy's communications for months, to this day the BOP has not taken any action to discipline Diddy for any purported violations of the MDC policies. Diddy has never received so much as a write-up in his 4 months in BOP custody, despite the government's repeated complaints about his alleged obstruction from MDC and supposed violation of policy. Third, the declarations confirm that the government was complicit in Investigators 1's continuous monitoring of Diddy's privileged communications. Investigator 1 admits that he listened to Diddy's calls, including with his counsel, and that all of those recordings, including the ones with his attorneys, are being furnished to the U.S. Attorney's Office. Finally, the declaration raises additional questions that cannot be fully and accurately answered except through discovery and an evidentiary hearing. As just one example, despite the reporting to the prosecutors that he potentially took photographs of Diddy's notes, the declarations are inconsistent with each other. They omit key details and rely extensively on hearsay and are remarkably vague on key points. The truth will only be fully revealed if the government's claims can be tested through cross-examination of witnesses who have actual knowledge of the material facts. Likewise, the court cannot fashion appropriate remedies without the complete information that can only be discovered through a hearing. The declaration also contradicts the government's prior narrative concerning its relationship with Investigator 1 and his motives. The government previously claimed that the case team investigation and the BOP investigation have operated independently, and that Investigator 1 was merely searching for contraband, not evidence, during the sweep. The declarations show that both of these claims were false. In fact, the government and Investigator 1 worked in a coordinated fashion for at least 2 weeks leading up to the MDC search, and the trial team encouraged Investigator 1 to monitor Diddy's communications. BOP personnel contacted Supervisor 1 on October 10, 2024 to inform her that Investigator 1 was monitoring Diddy's communications and found relevant evidence. That date is significant because it's only 10 days after Diddy filed his widely publicized notice of appeal concerning the detention order, and the same day the court invited the defense to make a renewed bail application. Notably, the Southern District of New York supervisors on this case have been present for all the court appearances in this matter, including that October 10th conference. Despite the government's claims that Investigator 1 was monitoring Diddy because of the purported violations of the BOP policy, Mr. Combs has never been disciplined or even asked by the MDC to stop engaging in the cited conduct. If Investigator 1's surveillance was generally undertaken solely for the penological purposes, why does it seem that the fruits of his work has only been used by the prosecutors and not the BOP itself? Clearly, Investigator 1 searched Diddy's notes during the sweep to find evidence for the prosecutors. He was not searching for purported contraband, as the government previously represented to the court. Declarations confirm that the government has, via Investigator 1, consistently monitored Diddy's privileged communications with his attorneys. In its opposition to the defense motion, the government claimed it made good faith efforts to avoid coming into contact with privileged material, and that is contrary to the facts and logic to suggest that Investigator 1 was an informant in the defense camp. Turns out Investigator 1 has been spying on the defense team all along. Investigator 1 repeatedly informed the trial team that he was eavesdropping on privileged communications, but the trial team never instructed him to stop. That is outrageous. Worse, the trial team has endorsed his conduct by requesting the communications at issue. Accordingly, the government has obtained and produced to the defense over 30 of the defense's own calls with Diddy. Instead of sharing the full story, the government has cherry-picked a few facts and submitted declarations that undermine the credibility of its previous submissions, omits key facts, and raises numerous important questions about what really happened. A full hearing in which Diddy's counsel are afforded the opportunity to cross-examine the government actors with knowledge of the facts relevant to the search is the only way to find out the true facts and understand the full picture, so the court can access how best to remedy this grave violation of Diddy's constitutional rights. Diddy therefore respectfully requests that the court order the government to produce the additional discovery described in this letter, as well as whatever communications it already has shared with the court in camera, and hold a hearing. Boy, I am literally crossing my fingers and hope that this turns out to be nothing. But if it does, I think that Diddy's really going to try for a mistrial. With all the uncertainty still around TikTok right now, please go and follow me on my YouTube channel, KadishaLynn, especially since all of the important details in Diddy's case are coming really soon. But y'all let me know what you guys think about all this in the comments.